Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. Tonight I'm going to flag something that's getting almost no attention, but should seriously concern anyone who cares about due process in the United States. The Department of Homeland Security is now trying to deny asylum seekers a hearing altogether, using a procedural move called pretermission. Pretermission is almost exactly what it sounds like. ICE is asking immigration judges to throw out asylum applications without ever even giving them a hearing. And here's how they're doing it. ICE is invoking an obscure provision of asylum law that says that the United States doesn't have to grant asylum if there's a third country willing to take the person instead. On paper, that sounds innocuous. But in practice, ICE is using this as a bulldozer. About 6 months ago, the Trump administration entered into an executive agreement, not a treaty ratified by Congress, with the government of Uganda. In entering this agreement, the United States designated Uganda as an asylum cooperative country. Now, to be clear, this agreement was not neutral. Uganda depends heavily on U.S. foreign aid, security cooperation, and refugee funding, which gave the Trump administration enormous leverage. This was pressure, not partnership. Now, ICE is arguing that because Uganda is willing to take these asylum seekers, the United States no longer has to give them a hearing at all. No testimony, no evidence, no credibility determination, just deportation to Uganda. And that alone should raise alarms. But the law makes this even clearer. Under the Immigration and Nationality Act, specifically Section 208, the government can only rely on one of these third country deportations if the United States can demonstrate two things. First, that the person will not be persecuted there. And second, and this is even more critical, that the person will receive a full and fair asylum process in that third country. ICE is actually almost entirely ignoring that second part of the equation. But it's an important question because Uganda already tried this once before with Israel, and it failed badly. About a decade ago, Israel sent Eritrean and Sudanese asylum seekers to Uganda under a nearly identical safe third country agreement. Independent investigators later showed that those people were detained, stripped of their documentation, denied access to asylum procedures, and pushed onward into extremely dangerous migration routes. Many people were harmed. Some of them disappeared altogether. And yet ICE attorneys are standing up in immigration court right now arguing essentially, hey, they can just go to Uganda, they'll be fine. That claim ignores both the statute and the real-world record. What makes this especially dangerous is how quiet everybody has been about it. There haven't been any headlines publicly announcing this. There hasn't been any press conference, and there haven't been even any executive orders. This is just an arcane technical legal move that allows ICE to avoid hearings for asylum seekers altogether. And that's the point. This isn't about efficiency. It's about erasing due process by design using an executive agreement Congress never approved with an underdeveloped country that has already demonstrated it cannot reliably provide asylum protections to anyone. If this stands, asylum law doesn't disappear because Congress repealed it. It disappears because hearings quietly stopped happening. People should understand what's going on here because once due process is gone, accountability goes with it.